This is Dr. Della Welch again, and I'm talking more about the third-party beneficiary issue. I wanted to say more about the incidental beneficiary. An incidental beneficiary is a party not intended or named by a contracting party to receive benefits, and they have no enforceable rights. For example, in the example I gave you about A and B entering into a contract, and then B decides to name C, his son, as a third party intended donee beneficiary to give him the office building, then suppose that D owns the neighboring lot, and D is just a neighbor, and the value of his home will go up a lot if a new office building goes in next to his property. Well, unfortunately for D is an incidental beneficiary, and they have no rights under a contract. Now I want to say more about an assignment. You should have a clear definition. An assignment is a clear and adequately described present transfer of contractual rights or benefits to another party after the original contract has been created. A mere promise to assign is not an assignment. No writing or consideration is needed for an assignment, but future rights are not assignable. An assignment terminates the assignor's right to collect anything on the contract. This is often in home mortgage situations. You may have your mortgage with a certain lender, and then the lender may assign that to another lender, and you simply pay your payment to the other lender. So you have to have notice. There's certain rules you can research that says first in time, first in right, and other rules to see if someone makes multiple assignments, which one is the valid assignment. Another thing I want to talk about is novation. Let's say that A and B, they have a particular fence between their properties, and they say, let's pay $2,000 to a contractor to build a fence between our property, and each of us pay $1,000 at $100 a month. Well, about 2 months into the contract, let's say that B gets drafted and C buys his home. Well, if they enter a novation, Novation, then all parties agree that B is substituted out and C is substituted in, and C will be able to be responsible for the payments on the fence. So all parties agree to take one party off and put in another person. Now, there's certain agreements that cannot be assigned. As suppose you enter a lease, and they're relying on your credit and your references, and usually they'll put a sign that in the contract, a little note that you agree not to assign or sublet the lease. So by contract, it may turn out that you cannot assign an agreement. Contracts for personal services can't be assigned. Let's suppose I love French cooking, and my cook goes on vacation. Well, he or she cannot assign the contract to a Russian cook. Suppose I don't like Russian food. So that's too personal. Suppose that Kobe Bryant, a great basketball player, got tired and didn't want to go to the championship game and said, I want to assign my contract and delegate my duties to Butterfingers. Well, that's too personal. He can't do that. And it's important to know that an assignment of rights usually includes a delegation of duties. Public benefits contracts are not assignable. You cannot assign Social Security benefits, Indian land benefits, or benefits such as that, because the person who is receiving it is entitled to the benefit. An insurance contract, suppose you have benefits through a particular carrier, you cannot assign that to another person. So we've talked about a novation, which is I always call a nova, a new agreement, where a new party is substituted in place of an old party. So think of the word nova. That's an easy way to remember it. Now I want to have a few true or false or multiple choice questions to review this. Duties are assigned and rights are delegated. That is false. It's just the reverse. Rights are assigned and duties are delegated. Some assignments must be in writing. That is true if they have the subject matter that the statute of frauds would require a writing, then such as a mortgage company loan or something like that, you must have that in writing. Now here's another question. The third-party beneficiary never obtains a vested right. That would be false. The incidental third-party beneficiary never obtains a vested right. However, the person may be an intended beneficiary, a creditor or donee beneficiary, and their rights may have vested. The original obligor remains liable after a novation. That would be false because the original obligor is taken out and the nova, or the new party, becomes liable. Here is another question. A mutual agreement among all parties concerned for the discharge of a valid existing agreement and the creation of a new contract, or the nova, is known as a novation. So these are important third-party concepts that you need to know. You need to know what a third-party beneficiary contract is. You need to know if the person is intended or incidental. Is the person a creditor to discharge a debt or donee to make a gift? What was the intent behind it? And then are they vested? Are their rights vested? And depending on the state, there's certain rules on vesting, whether you have to materially rely, go purchase equipment or something like that to have your rights vest, or just simply upon the very making of the contract. So you need to check your individual jurisdictions on that one. And remember, the intended beneficiary obtains